My anticipatory bail application just got dismissed. What should I do? This person just called me up, asked me this question, and I had to explain to him that anticipatory bail applying for, there is a 3-step process, and even if those get rejected, there are several other things which can and must be done. You cannot just give up and resign your fate to life in jail. This person's anticipatory bail was rejected by the Sessions Court, the first place where the anticipatory bail application can be filed under Section 438 of the Criminal Procedure Code. Now, this person for some reason just surrendered and just gave up. Why? The first and foremost thing that I tell every person who walks through my doors to whom I recommend applying for anticipatory bail is that Sessions Court judges, being in the district courts, there is a very high chance that they reject your anticipatory bail application even if you have a good case, just because they are always afraid of the High Court sitting right above them. Because if, and I've spoken about this in other terms on other occasions, if the judge gives bail to a person, there can be fingers which can be pointed, and the judges might say at the appellate level, the judges might say you might have had taken a bribe. But if a judge rejects any bail application, nobody ever points a finger and says, how did you reject this bail application when it definitely had some merit? And that is why I tell all my clients there is a much higher chance of the High Court of any state, be wherever it is in the part of the whichever part of this country there might be a High Court, they have a much more higher chance of granting you anticipatory bail, especially when there are false allegations, such as in this particular case of rape on the promise of marriage. So the Sessions Court rejects your bail, you go to the High Court. The High Court rejects your bail, you challenge the order dismissing your anticipatory bail application before the Supreme Court with a special leave petition. And it is not very, the chances are not that great, but they're not that bad either. The Supreme Court, on its part, the judges do read the files. In fact, I feel that the Supreme Court is one place where every single judge, before they sit down, so as to save time, they read every single file that comes their way. Of course, some things they miss, sometimes they misinterpret. There's also a lot of good drafting which is needed to be done for the Supreme Court. Having said that, whatever be the outcome, for the purposes of this video, in case the SLP is also dismissed by the Supreme Court, you then surrender before the trial court. You then again move a bail application. If it's a sessions tribal case, you move that bail application straight away before the sessions court. If it's a magistrate tribal case, you first move that bail application before the magistrate. Against that, you go to the sessions court. Against that, you go to the High Court. And if it is a sessions tribal case, you move before the sessions court. If not there, then the High Court. Ultimately, you can always end up there in the Supreme Court. And even if the bail is dismissed, then after a certain amount of time, maybe after the witnesses have been examined, maybe after the charge sheet has been filed, maybe after the charges have been framed, you can move these bail applications again and again and again. You do not give up, especially if you're falsely accused, if you're falsely impleaded. There is always a good chance that you can get out of jail. It's more about strategy and a little bit of luck more than anything else. In this particular situation, the person called up and said, I want to apply for bail, but what do I do? Now we are agreeing to marry the girl, and I explained to this person, don't marry it. As a side note, I explained to the person, don't marry the girl because you're starting out your relationship where the girl has filed a false case against you. Now she has forced you to marry her. If things don't work out, then there is a far greater chance or far greater potential for damage. If she is that kind of a woman, there is a far greater potential for damage to be inflicted upon you. So don't take that risk. You're already in jail. A couple of weeks, maybe a month or two, you spend in jail, but then you come out and then you're done with the situation. There are other things as well involved over here, so we don't go into the technicalities of this particular case. But the lesson for all of us over here is, one, we do not give up when the Sessions Court dismisses our anticipatory bail application, because there's a much higher chance that they will dismiss that anticipatory bail application for the aforementioned reasons. You approach the High Court of your state, have your fingers crossed, you have your lawyers do a good job. If not there, the Supreme Court. And even if that does not happen, then you tell yourself that is a few weeks or a few months time. You get to learn a lot in jail. I've had a lot of clients tell me that, so you look forward to that as well, just in case these things don't work out. And at the end of the day, you ensure that you have enough to get a not guilty verdict, because what will actually pinch is when you have to serve that 6 month, 1 year, 2 year period of sentence. In fact, if it's just 6 months, 1 year kind of a sentence, you will anyways get bail from the courts at the investigation stage. Now we are talking about cases where the allegations are of rape, murder, cheating perhaps, where you can face imprisonment for up to 7 years, 10 years, maybe even life. And in those situations, right, you need to want to ensure that even though you might have spent, maybe worst case scenario, a couple of weeks, months, or maybe a year or two in custody, you at least definitely do not want to extend that time to 7, 10, or a lifetime.